Welcome to the Landlording Show. This is the podcast where we not only show you how to get investment properties, but we actually show you how to take care of them and how to make sure that you are maximizing your value and your performance of those investments. My name is Tim Harstead. I am your host. I run a property management company in Chicago, Illinois, focused on a lot of C and D class. And today we have a special guest, Tosh Chandy from the law office of Tosh Chandy. Tosh, how you doing today?
Good, Tim. Good afternoon. Thank you for having me.
Thank you, thank you. So Tosh works a lot, and what we're going to focus on. He does do real estate closings, and we're going to talk about that a little bit later. But one of the things I wanted to focus on first that he specializes in is dealing with the city of Chicago and building violations. So whether you bought a building that has building violations already on it, or the city came by from a tenant complaint, or just drove by and found something, we really want to give you guys the best advice on how to handle those situations. Um, Tosh, first of all, give me a little bit of a background of yourself and your firm and what kind of work you guys do, and then we'll jump into the uh, the violation side of things.
Sure thing. So I've been an attorney now for about 6 years. Like I said, it's the law office of Tosh Chandy. It's just myself and a paralegal. About 50% of the business involves real estate closings, both commercial and residential, buyer-seller representation. Another quarter is building violations, and that kind of stemmed out of my real estate practice. All kinds of city violations. The other quarter% is homeowner association disputes, civil lawsuits, partnership disputes, LLC disputes, creations of those entities, and anything involving those entities. So I was a realtor for more than a decade before I became an attorney, and I've worked in finance, but now I've kind of brought everything together in this role.
You went reverse. I know a lot of attorneys that get their real estate license just because they don't have to take CEs, but
Uh-huh.
you went and got
Right.
your attorney license. Nice.
Yeah, right.
Cool. So let's walk everyone through the process. You get a fun little yellow letter in the mail, or they post it on the door of the building saying, "Hey, an inspector stopped by, and they flagged your building for X, Y, and Z." What are the first steps that they should take, and how's the best way to proceed?
Well, certainly don't ignore these letters. Certainly, some people, they come to their PO boxes or they come to their registered agents if they're an LLC, and they just kind of ignore them. That's not a good idea. So, the best thing to do is either to consult an attorney, myself or somebody, and or follow the instructions on it. Some for very minor violations, you can simply just plead liable and guilty, send in a fine, and that'll be the end of that case. So, depending on what notice you get, there are usually three types of notices: the 20 notice, which is a warning; the 50 notice, which is non-dangerous or hazardous conditions. These get sent to administrative court; or the 80 notices, which involve safety or major cases, as we consider them. Those go to circuit court. So depending on which notice you get, the courting action would be different. So the 50 notice, if you get administrative court, sometimes you can mail these in, plead liable, and also the streets and sanitation cases fall under there. So many of your listeners probably have got uncut weeds, no fence, or uncut grass. These are minor cases. You might want to just plead guilty, just like a parking ticket. Send the fine in, no big deal. The more serious cases involve larger fines. It's best to seek representation on these. And for the circuit court cases, if you do have an LLC and an entity, you have to actually have an attorney. It's required. The LLC can't represent itself.
Yeah, so talk about that, and I'm sure you can touch on the eviction side. I'm just going to touch on this a little bit more. One of the negatives, and there's a lot more positives than this negative, so I'm not discouraging anyone from doing it, but one of the negatives of LLCs, and we're actually seeing judges turn people away on the eviction side of things. If you put your building into an LLC, even if it's one of those LLCs that it's just you and you're just moving it over for liability purposes, the judges are often not going to hear your case, even if you're serving the 5-day notice for an eviction, or in this case, civil lawsuit. Um, what is the rule on that? Basically, if it's a business, you cannot represent a business without being an attorney, correct? Or is there a different variation of that?
No, that's correct for circuit court because the circuit court cases fall under the Illinois Supreme Court. So the idea is that that LLC is not a person. It's a corporation. So the idea is you can't come in there as a managing member of the LLC and represent yourself. You need to hire the legal counsel for that. Now, administrative cases used to also be like that at 400 West Superior, and it's interesting because there's still an argument about this because there's a case pending. So there's really no clear guideline on this. But if you have an LLC and administrative court and you come in with documentation showing you're the managing member, or you have the authorization to be there as an agent for them, they will usually let the administrative cases go through. But some of the judges in there still also believe that you should have representation.
So it's 50-50. And a lot of times with those administrative ones, like you said, if we're talking about lawn cuts, it's a
Right.
$50 case. If you are able to represent yourself, great. If you have the time, I often am a big believer of what is your time worth, and it's worth more than $50 an hour.
Exactly, and many of my clients don't even live here. Yeah, they don't even live in states. So obviously,
Yeah.
if you live in New York or California, you can't show up, right? So you got to.
And to pay an attorney a fee for something, just you gotta. I get that there is a principle of things, and oh, this isn't true, or oh, this is a picture of next door, and you could probably beat it. But sometimes when they call it Crook County for a reason, and sometimes it's
Mhm.
easier to pay the $50 fine than to
Yeah,
fight
but
them.
the fines are getting high now. I mean, they're even for the uncut grass or the dumping, the illegal dumping and waste. These are some of them are 500, 600, 350, 300. I mean, they're getting up there in the city. So if you have two or three of these on one property, if you send me in, I could probably knock out two of them. So now you're stuck with the minimum 300 on one plus $60 court cost plus my fine. It's still better. You still benefit.
Makes sense. Yeah. So I guess it just depends on what the fees are and all that. And like I
Right.
said, yeah, it's the city is getting more and more expensive. Let's go back to the higher ones, the higher end ones. So you get this letter and it's going to circuit court. Oftentimes, it's at least for me reading them, you almost need a law degree to figure out exactly what they're saying you need to fix. What do you think is the best
Mhm.
action to sort of get an idea of what they actually want done or how they want it done when it's not clear?
Okay, so for those, whether administrative or circuit court, it is not clear on the documents you receive. So, like I say, if you hire someone as myself or an attorney, we can guide you through that process and let you know. Otherwise, you can go online if you have the wherewithal to look up the Illinois statutes for the building code, the municipal building code, type in the numbers and put in quotes into Google and you can kind of see what they're referring to, what your actual violations are. But you have time. In either instance, you have time, especially with the circuit court. Uh, they give you quite a lot of time to figure out what your issue is and what can be resolved. Same with administrative court; they do give you enough time.
Cool. What are you doing when you go to these cases? Sort of walk us through sort of what the procedure is and what you're doing. I know a lot of it is just your relationship with these city, the city judges and the city
Mhm.
attorneys. But walk us through a little bit of that process.
That's a good question, and I'll break it down this way into these buckets. So you have the circuit court versus administrative court. Circuit court is at Daily Center. It works just like typical court cases that you might see on TV. You file an appearance fee. There's a defendant. There's a plaintiff. You show up. Usually these are more serious cases. You don't go before a judge usually on the first date. So what I do usually on the first date is I filed my appearance. I represent myself as I'm the attorney for my client or for the LLC. The city will pretty much enumerate their charges. They'll say, hey, you got a porch that's crumbling in the back, you have a foundation that's crumbling, roof is falling off, it's not safe, you have an illegal basement unit that they need to be out. If it's something very serious, the city can issue an injunction. So this is going to be a real issue for you at this point. Now you got to get people out right away. They'll come and evict your legal tenants out. If there are things that can be remedied over time that they don't feel is going to collapse the next week. If it's some masonry work, for example, falls under there, they'll give you usually a long date, usually a 6-month date right off the start. So at that point, I then get with my client and I let them know, here are your issues right here. Hire the contractors, get the permits, start on that process because this takes time. Start doing the work. Hopefully the work will be done by the next court date. If it's done, the reinspection will happen a week before the court date. I'll appear back in court and everything will be dismissed. No fines, no fees. You're out of there. If you need more time, I usually can get another extension. And at that point, if you're not done, usually there will be some kind of fines imposed. Now, another thing that I can do is I look at that complaint and I could see if all the charges are valid. Usually they are. Usually, I'll say usually inspectors don't really write up things that aren't true. But sometimes I've seen things that are written up in duplicate. For example, if you have an 8 unit or 12 unit and the buildings are separated by a courtyard, sometimes it says loose masonry or lintels, deteriorating, but they have it on both portions of the building when really it's only on one. So maybe it's on the left side of the courtyard, not on the right. So I can kind of knock these charges off and have the city have the inspector come back and look at them and say, okay, yeah, we overwrote this, and okay. So that's the circuit court. The administrative court, when we go in, the charges are usually more minor. There might be some slight electrical, a lot of remodeling without permits. Same thing. You get the permits. We get another 3-month date. We have a reinspection, or we send photographs for the work completed, and we knock those out without fine. So at that point, at either of these situations, you're not pleading liable to any of the violations. You're getting them dismissed. But with the administrative cases, if you don't get them cleared within 3 months, 4 months, I'm seeing now that the city is not really giving that leniency, especially with electrical and porch violations. What they're doing is they're making you take account of liable at least on one charge. So say you have 6 charges, 8 charges, they'll make you plead liable to one charge, so you will have a fine on that one charge, if that makes sense. But the real goal is to get
Gotcha.
compliance,
What
and
are
they call it
the
subsequent compliance. Get the compliance even later.
Gotcha. These fines, like, so we accept a fine. What does that mean in terms of, are they like, if you plead liable, do we still need to get the work done, or and take the fine that we're still getting the work done and they can come back, or what's sort of the process there?
Right. So that is a good question also. So if you plead liable, you're saying the work is not done. Technically, it goes back to the building department, and they do have a right to come back and write it again. Does that happen? No, it doesn't happen because they have thousands of these cases. So you're taking the liability and you're taking the fine, but there is a chance if a tenant calls or somebody else calls or somebody happens to drive by in the future, they can write it again because that the issue hasn't been corrected. But the city does allow on all these cases pretty much subsequent compliance, except for the grass and the uncut weeds. That's strict liability. They say we took a picture, you got to pay something. Now, this is different than the suburbs, especially when I go to the south suburbs. They don't allow the subsequent compliance. So when they write the
Mm-hmm.
violations, they need you to fix the issue, and you still will usually pay a fine, even if it's a minimum fine.
Mm. Gotcha. The other thing I want to talk about, that you brought up, the city doing evictions. So let's say you do have a building. You bought a building, you had no idea how bad it was. Sometimes we get investors that don't do the due diligence that we preach for them to do, and they come to us afterwards. But
Mhm.
this, when the city wants to shut down a building, that eviction process, how does that work? Are they able to do an eviction faster than the 8 months that we do on a civil eviction, or how does it work with the city shutting down the building?
In the circuit court, at the daily side, depending how backed up they are, and with the sheriff, it is usually faster than certainly than a traditional eviction. If they feel that the unit's dangerous, or they feel somebody's living there and they're not leaving, and it's an illegal basement, and the electrical and plumbing are not hooked up to code, and they're not in a safe manner, they do have a process where they have some kind of um, engagement with nonprofits and other groups, and they'll try to place these tenants or even give them a hotel for a couple of weeks. Same thing that happens like in a fire, for example, in a building.
Hmm.
And they do remove the tenants a lot quicker than a regular eviction. Yes.
And then how do we go about? Let's say they remove them, we fix everything. Are we going to have issues getting occupancy approved again, or is it just sort of fix everything and then the city will grant it, or is there sort of a judgment of like, hey, you guys were pretty bad before, we don't want to let you house anymore?
No, no, no. I haven't seen that. If it is a legal garden unit that just was rehabbed without permits, no, definitely you can put someone in there right away. If it's an illegal unit, you have to go through the process with zoning, and you have to figure out how to get that legal.
Gotcha. Cool.
So yeah,
Yeah,
just because you rehabbed without a permit, or yeah,
no, awesome. Yeah. So okay, yeah, no, we actually was just talking to someone that has a building that I guess there's a lot of gang violence. So the city is considering, and this is actually a south
Mhm.
suburb village, but they're considering doing just basically saying that it's uninhabitable and vacating it from the police order. So I was just curious if if it's going to be hard
Yeah,
to get that back opened up after everything's
I had a
fixed.
client like that in the south. Yeah, I had a client like that in the south suburbs in, I believe it was Harvey or Markham, and they had a larger building, and there were a lot of extra cars parked in the back and on the sides, and people hanging out. And the city, that's what the city wanted. They wanted to like condemn the building and take it from my client. So we had to fight that. We said, I mean, he's doing everything he can. He had to hire a security guard,
Mm.
like, in a vehicle. He had, put armed doors and everything. So, I mean, once we showed that he's done his part, and it's really up to the city, that smaller city, and that police department to do the rest. We got that removed. But yeah, that was their approach. Like they are very heavy handed in some of the cell service.
Gotcha. If they did get to the point of condemning, because
Definitely.
so for this guy specifically, um, he inherited all these tenants. He doesn't want them there either. So is that sort of a tactic that he could take in terms of letting them condemn it and then just getting occupancy after everyone's out?
Yeah, I figured that's where you're going with that question, because people have asked me that also. Like maybe that's a good way, and I guess you could think that. It depends on what your situation is, how large the building is, how many tenants are paying and not paying.
Mhm.
You know, kind of, can you afford to lose that income in the meanwhile? Like say if some of them are Section 8, you know what I mean?
All right.
I think it really comes down to the financial situation there.
Makes sense.
But sometimes, yeah, that might be a better approach to go through that process.
Awesome. Awesome.
And if you have a very horrible situation, yeah, with the majority of the tenants.
Yeah, cool. And then what is sort of I guess the other part of this is, going into real estate closings a little bit. I know that
Hmm.
we often want our attorneys to run searches and things like that. And I've noticed that the online database isn't always the quickest to be updated. So what's sort of the best way if I clear all my violations I want to sell? What's the best way to make sure that the buyers aren't getting scared off by these violations being online?
Yeah, definitely. So when I represent buyers, of course, in my attorney review letter that happens during the attorney review period, I always ask, are there any open violations, whether they're still pending or they're closed? Were there any in the past 5 years? So at that point, I'm putting it on the seller's attorney and the seller to be honest with me, to disclose those. So I'm putting that burden on them. So at that point, they should disclose if there's still anything open. Besides that, of course, we run the title search through a title company, and this will also find there are any pending cases or pending violations that are open. Now, I will say this: if there are cases that an inspector has written but not submitted to court, those will not show up in that title search. And there are some cases that end up like this. For example, the inspector comes, but he doesn't think these are super serious. They're kind of minor, but he has to document something, but he doesn't keep it in the warning code. I don't know how this happens, but it happens sometimes. It goes kind of into a flux state, like a limbo state, where you, even as the owner, you can't petition the court and say, I want to close these violations. I want to pay for these. They're just in limbo. So the best thing to do in that case is, just as an owner, and do your due diligence, just get those things done. They're very minor things. Just get them done. So you're not passing on this burden to the next owner, just in case the city comes by. You know what I mean? And they write those up.
Cool, makes sense. So what else should if I'm buying a building, what else should my attorney be doing or checking for to make sure that I'm not running into issues after closing?
Right. There's a lot of things. I mean, the attorney review, I mean, of course, you'll have inspection issues and repair issues. If there's things you want the seller to remedy or correct. Um, of course, we check for liens. We check for any kind of unpaid contracts. The water bills in the city of Chicago, as you know, like in a lot of the news articles, some of these properties have huge water bills. I'm dealing with one right now that has a water bill that's close to $87,000 on a 4 unit. So, I mean, these come into play, and who's going to pay that? Is the seller planning to pay that? Because it's got to be paid.
Hmm.
Or, are they going to now say at the last minute, hey, we want you to pay for some of it. So there's that. The survey, I run into survey issues, not too often, but about a quarter of the time in the city, where there are fences built on other people's properties, property lines. There's driveways that are not, correct. There's garages that sit a foot over the neighbor's yard. I mean, these are things you gotta think about, because you're inheriting, a potential problem. If that neighbor says, hey, wait a minute, 2 feet of your garage that, might be worth 60, 50 grand is now on my property, and I want that off of my property. So these are things that have to be discussed. And title won't insure over that. They might insure over that for the lender, but they're not going to insure you for that. So it's a problem you're taking on. And sometimes the risk is worth it. If it's an inch or two, what are the chances? But sometimes they're bigger issues. Of course, with these building violations and open violations where they went to court and pled liable, but the violations are still there, your inspector might find them. Your inspector may not know about them, if they're not familiar with city code. So, I mean, these are risks that are there. Especially, I see a lot of them with vacant properties. Especially like in Inglewood or East Garfield Park. I mean, some of these buildings are great buildings, but I mean they're filled with violations, and people write these blind offers, cash offers, and transfer properties with quick claim deeds. And now you have tons of work that you're going to have to do. The city's going to make they're going to make you do, and if you don't do it, especially if it's in circuit court, they'll put that big red X on the building, and they'll be the end of your building. You know what I mean? Now, I've had clients who bought buildings from out of state. I didn't represent them. They called me later, and they thought, oh, it's a great deal. It's 200 grand. Who cares? They're from California. To them, that's nothing, And then they realize, wait a minute, they're tearing my building down next month. Yeah, all right.
Yeah,
Good job.
there's and I think that especially out of state investors, you need to be aware that especially south side of Chicago, and I'm sure on the north side as well, but I deal mostly on the south side. There are going to be people that are trying to scam their
Uh-huh.
way out of a building, and $50,000 buildings in a major city, there's a reason it's that cheap.
Yeah.
Like if you're buying a building for 50
Right.
grand, there's issues there. It's probably not going to be rentable, even if it's in
Hmm.
these neighborhoods, Inglewood and things like that that you hear on the news. What's the quote or whatever? If it's too good to be true, whatever that one is.
Yeah.
There's got to be something,
Yeah.
and I think some of these can still be good investments. If you're buying a building for 50 grand, you got to put 100 grand into it, and now it's worth 250. It's still a great investment, but I see a lot of people that
Hmm.
call us and we can't help them because they have $60,000 to their name, and they bought a building for 50,000, thinking it's going to be rent
Right.
ready. So I think obviously going
And they're in
in
over their
over their
head.
head,
Yeah.
exactly. And I think obviously the first one
Yeah.
is never buy a building without an inspector, and make sure that in my opinion, make sure you're finding the inspector, or you really
Hmm.
trust your realtor to give you a good inspector, because
Or the
yeah,
realtor,
because
right?
there's a lot of realtors that just especially if you're working with the list agent only. I can give you inspectors I know that will write reports that make a building falling apart that I would never recommend. Like they're on my do not use list, but they're out there where realtors, listing agents will use them to say, hey, cool, you're coming to work with me as a non-client. I represent my seller. Here's a guy that will
Hmm.
write an inspection list for you, and it'll be the cleanest
Yeah.
list you see. So. You really got to be careful who you're trusting and whose eyes are on the property. In my opinion, when you're buying these
Hmm.
properties, um,
Yeah, it's hard now. I mean, the $50,000 building is gone. I mean, even in Inglewood. I mean, a couple of years ago there were, but even in Inglewood, I
yeah,
mean, you're looking at 100 plus, 150 plus, even for total guts. And same in other upcoming areas. But to your point, what I tell realtors and people looking online and searching on Zillow, when you see those buildings sitting there, like in these areas where they're great new development, and you see these buildings for 100 grand, 125,000, 4 units, 3 units, there's a reason why they're still on the market there. And a lot of them have illegal basement units. A lot of them have major porch violations. These are two very common things, and they're not going to disclose that. And even the realtors, the listing agents, don't disclose it. They list them as 3 units, and I'm like, well, why would you do that? It's not a valid three
yeah,
unit. It's not legal.
and
It's not a legal basement, and they put them on unless it's
yeah,
3 units.
touching base on a porch. If it's a wooden or a steel porch, that's on a 4 unit building, that's an easy 50, 60 grand because of all the permits and all the.
It's a lot of
Yeah,
money.
it's a lot of. I mean, it's just like you said. It's almost as much as some of these properties to get this rebuilt. So you got to be.
Yeah, I mean, these things got to be disclosed, and if as long as there's transparency, if you have a good attorney representing on the buy side, and the seller's attorney is also diligent and not just doing. And I'm not disparaging attorneys who do volume business of closing 200 a month. But some attorneys don't look at any of this stuff. They have two or three paralegals doing their closings, and you get to the closing. And if you're not diligent buyer's attorney and asked for these things ahead of time, you're at the closing and you realize, wait a minute, it's not a 3 unit because this zoning certificate says it's a 2 unit. So now they've overpaid. You realize there's violations. You realize the survey has got all these encroachments. So, and it's a shame because a lot of attorneys who do closings, they look at it as like, this it's a simple enough thing. I could do a closing, I could do it quick. But if you don't reach, all the issues come to head at the closing, and now you're trying to argue and figure out how can we get this deal done still.
Yeah.
So I try to ask all this stuff in the
Ask it
first
up
week. I try to
and the
look
other
into
one
it
that as a property manager slash realtor as well that I'll bring up is, in my opinion, you get the attorney review, you do your inspection. I always want the credit. I don't want them fixing it because, I've seen too many times where, hey, we need a new boiler and, it's going to be 30 grand. Okay,
Yeah.
yeah, we'll get a new boiler in there. And, they slap a stick
Hmm.
of paint on it. And if you're not doing a proper
Hmm.
inspection with either the inspector coming out or an HVAC.
And you don't know as a buyer, you don't know how to
Yeah,
inspect that thing anyway, right?
exactly. Like you need to have a, because you can show up and it looks nice, but if you don't have an H, for we had a guy that bought a building and the boiler was all messed up and they put a new boiler in, but the boiler itself wasn't the issue. It was all the pipes running from the boiler, so that's another
Mm.
$150,000 job, and unfortunately that building was not successful for him because instead of just getting it done right and taking the money to go ahead and get your own HVAC guy, he had them do it, and
Hmm.
they, like I said, they basically put lipstick on a pig and said, hey, it's done, let's close. So you got to
Hmm.
be wary of that for sure. Um, the other thing I want
Hmm.
to talk to, and I know we're talking about vacants, but let's go to occupied units. What are you looking for? Someone sends you a rent roll. Is there any way that we can, as buyers, verify that or have any better than the seller saying, "Oh yeah, I collect $1 million a month. Just trust me."
Well, usually on the buy side, what we ask for is that rent roll, and there's an affidavit that they can sign that says, these are the real rents. I also ask sometimes for accounting statements, depending how large the building is. If it's a larger building, sometimes they will share like their balance sheet from a CPA or their income statement. Sometimes they will share that, depending how the size of the transaction, I
Yeah.
should say, depending on the size of the transaction.
And then with that affidavit, is that something that you could go after? If you buy let's say you buy a 4 unit building, you sign an affidavit, say everyone's paying 1,000, and you get there and you realize that these tenants are all 6 months behind and have 100 people living there. Do you have recourse at that point, or
You do have recourse, but to be honest, Tim, usually the ones I've dealt, I haven't run into that situation. I ran to one that was $100 off. Well, actually, their rent was increased by $100, but the tenant had never paid the extra $100, and the seller didn't disclose that. But I haven't really run into a situation where it was an egregious, outright lie like that. I haven't run into that, but you would have recourse. But whether it'd be worth litigating or not, I guess depends how much the amount was. It
makes
depends
sense? But I
what the
think
price was.
asking for this stuff and having an attorney that's actually getting another attorney to supply it, I think it's a lot less likely than the seller lying or
Well, that's my goal. My goal is to put that seller's attorney and his
yeah,
ethical, standards
yeah.
on the line. That's the idea, right?
Well, and then
That's the idea in there, and that's what we usually go by. So, like I said, I haven't really had situations where people were kind of egregious on that. I've had situations before at the last minute where um, they showed me an updated title commitment. I asked for
yeah,
updated title commitments right before closing, and they send me the old one, and then at the closing, I see a new one that's got 4 encroachments on the end, and I said, "Well, wait a minute, why didn't you send me this? Wait, show me this today. When was this rant? Oh, last week. And I think that's kind of a sneaky way, and I don't know if it's intentional or not. I can give them the benefit of the doubt, but I think that's a little sneaky sometimes. They hope the attorney's not going
yeah,
to catch it. They're going to look through the title. Oh, that's a title,
yeah.
great.
No,
Because
makes
you
sense.
know. But I catch it. I catch each line on that thing.
Last thing I want to talk about closing, and I've seen a couple people sort. I mean, it's funny when because we'll get calls when one of our clients sells, but letting the tenants know about new ownership. I know my attorneys will have an estoppel letter signed by the sellers to let them know that, hey, this is who you pay now and all that stuff and delivered.
Hmm.
Can you talk a little bit about that and what the proper procedures are to make sure everything with the tenants proceeds correctly after closing?
Yeah, it depends. I mean, if they have valid leases, you do the assignment of lease, and like you say, in the estoppel certificate, you can use that. We transfer security deposits usually at the closing. I've had some attorneys do a more informal approach, such as they Zelle over, the seller just Zells the security deposit over to the new buyer, and they hold them. Sometimes you run into situations where there's no valid leases. Everybody's month to month, so now you need to incorporate a new lease. I mean, it kind of depends on what the situation is there, but in a traditional sense, you'd want to definitely use the assignment and assign all the leases over for the duration, and then the estoppel certificate, you can use that as well, and then transfer the security deposits, or transfer at
Awesome,
closing.
awesome. Um, and then I think that the other quarter part of your law firm that you deal with is civil disputes and partnerships. I know a lot of people out there that are buying real estate as a partner because, a lot of times one person has the money, one person's doing all the work, or it's just two people that are equal and but just have
Mhm.
different skill sets and they become partners and sometimes partnerships go well and other times they don't. What are, in your opinion, any pitfalls that you've seen that might help people either pick a better partner or keep a partnership afloat or end it civilly versus having big issues?
Yeah, these are longer cases. Some of these cases go on for a couple of years. I mean, a lot of them stem from breach of contract or breach of fiduciary duty. These are the two of the larger ones that end up in my civil department. So breach of fiduciary duty could be anything. It could be one partner not showing financial records to the other partner. So sometimes you have a silent partner who
Mm-hmm.
puts up a lot of money, okay, and it's handling money, and then you have another partner who's here locally doing all the grunt
Yep.
work, and taking care of the buildings. Um, After some time goes on, 6 months or a year, one of the partners says, "Oh, okay." Well, the one handling the money says, "Yeah, we're not making any money." The other says, "Well, why not? Everybody's paying rent. Section 8's paying. What's going on?" "Oh, well, you know how it is. Like, yeah, there's nothing. We have no earnings to distribute. Like, there's nothing going on. Or can you contribute another? We got to get 20 grand from somebody else. We got to bring more investors in." And then you file a breach of fiduciary duty because at that point the partner is not disclosing business records. They're not sharing any of the documents. That happens sometimes. Other ones I've had in terms of commercial, I've had partners who are like partners in a restaurant, and they go open a competing restaurant like few miles away with the same similar idea, similar logo, all the similar similar distributors and food items. And one party says, "Well, wait a minute, you know what I mean? Like, how are you going to do that?" You know what I mean? And it's important to put these things in your initial partnership agreement, or even to have a partnership agreement. Some people say, "Okay, we're partners, we're both on the LLC, but do you have an operating agreement? Do you have terms of this agreement?" So hopefully you do. There's cases where I have general contractors hire subcontractors, and the whole project goes bad, and the contractor is now has to sue the subcontractor, because insurance won't pay out. So it depends. I mean, do your due diligence ahead of time. I mean, try to put a lot of these things into writing. You can't predict everything, but try to have a good operating agreement, partnership agreement up front that kind of delegates responsibility, delegates how often you have to disclose things, what the transparency level is, and what are the recourse for them. You know what I mean? Because there's law. These are all, codified laws, but they're so vague. Like what falls under that is sometimes
So
tricky. And the cases are so vague. I
no,
mean,
so you're saying for your protection, like the operating agreement is probably the most important thing, but also just like we do with leases, I think one of
yeah,
the
part.
issues with the biggest issues with leases is they're not specific in terms of you can say, hey, you're not allowed to have dogs in this unit. But if you just leave it at that, well, what's your recourse? Your only recourse is to sue
Right.
to
Yeah.
evict them and try to get them out. And sometimes the pet iguana isn't doing that much damage. You just want the iguana out, not them. Having our
Mhm.
leases are very specific that, hey, if you have a pet, this is the fine you have to pay every day until that pet's gone. If you're smoking, here's your smoking fee. Just like in a hotel and all that stuff, they have it posted. Um, would an operating agreement be the same in that sense
Yeah.
where you
Exactly.
could
Yeah.
say, hey, if you do this, this is the punishment that we agree on?
Yeah, you can enumerate some of them. Like I said, other ones are dependent more on a judge and or a trier effect in terms of what the damages would be. But you could at least say you can at least stipulate what will be violations that are clear violations. You know what I mean? Like a non-compete or not to open another similar in likeness restaurant within 20 miles. You know what I mean? This is a simple one you could have put in there. You know what I mean? Because now you have to litigate in court. Was that really a breach of their loyalty to the court? Was that really a breach of their duty? You know what I mean? And that takes time. And there's motions to dismiss that will come now, three or
Yep.
four from the defendant. You know what I mean? This is not a simple like you go there one time, the court and
It's
the
not
judge says,
like
"Oh, okay, yeah." Even if it's a simple case, it takes time
it's not
to
like Judge
litigate
Judy
through.
where it's
I mean,
all solved in 15
they're,
minutes.
they're, they're no, and I hate to say it again. It's in circuit court, and some of these judges I've literally had, and it's not to disparage judges because as attorneys we don't do that, but I mean I've had judges where they have to pass the case to another judge because they kind of rotate the daily center sometimes the judges, and they say, well I can't even do this hearing. I don't, and this is not something I know about. You guys got to come back. So it's a long process. It's not simple. Like when people say, "Oh, I'm going to sue my partner. I'm going to sue him." Yeah, okay. So you're on it for a long road.
No,
You're.
no,
And when it comes to closing, I'll say like for commercial closings, another thing to do is to look into liens, UCC filings, equipment loans on equipment. Sometimes people are trying to sell the business and the equipment inside, and lo and behold, there's $100,000 of debt on some of this equipment. You know what I mean? That somebody's going to have to take care of. So
all,
I
no,
just want to mention that in
awesome.
terms of
I'm
closings.
gonna start wrapping up because we are starting to run out of time. But I want to give you the floor and let you pitch your office, or
Okay.
let you tell everyone anything more about you or how to get in touch with you. And we'll leave that info below as well, how to get in touch with you in the description. But if you just want to verbally let everyone know, we
Okay.
can go from there.
Sure. Great. I think the best thing to do is to email me or go to my website. The website's attorneytosh.com. So it's attorney and then my first name, TOSH.com. The email address is tosh@attorneytosh.com. So it's also easy. Or you could call or text. I do try to answer my phone text within like 24 hours or less, 773-724-1049. A lot of items are flat fee in terms of closings. Usually they range from 575 to 750. Significantly more if they're larger commercial buildings. In terms of building violations, my hourly rate is $3.50 an hour. Usually, that's what one appearance will cost. If you do more volume, of course, we can work out a different pricing structure on the building violations. Yeah, feel free to call me or contact me. And like I say, I'm always open to helping people out. I just had a call yesterday or 2 days ago. It was Sunday, but I called the guy back Monday. He had met me at a networking event. He got a stop work order on a multi-unit. He's like, I'm kind of panicking. It's my first building. What do I do? So I looked it up. I saw there's no court case. He said he called a different attorney, and the guy said, "Don't worry about it. You don't have to do anything. Just like get a permit to finish it." So I said, well, "Wait a minute. Let me just see what's going on." So I contacted the supervisor at the city, and he said, "You know what? It hasn't gone to court yet. I'm not even going to send it to court. If your client can just get these following two permits, because he's got the wrong permit, that's his issue. If you can get the right 2, 3 permits, he's only got a window permit, but he needs these 2, 3, I think 3 permits. You get those permits, I won't send it to court, and move forward." And I didn't charge this guy for that, but he really appreciated that I took the time to give him the real information. Another attorney said, "Oh yeah, I don't know, just you got a permit, you'll be okay." And he could have been looking at a serious
Having the
circuit
wrong
court
permit is
case
a
there.
whole different discussion. But yeah,
Yeah. So if it's something I can, right, if it's something I can do, relatively easily and quickly, and through my contacts, I can email somebody and get an answer. As you know,
absolutely.
Tim, like I try to do that, and I don't charge for that half hour of time or
Abs-
something. It's not. That's
Absolutely,
not
and
how I built
I
the
want
business.
to say thanks again for hopping on and just to give our vouch for Tosh. We use him on all of our cases as well. He's gotten our clients out of a lot of jams, so very good guy to have in your corner as we all need that team to be built when you are investing in real estate. So definitely someone to have. If you've listened to this and if you've liked what you've heard, please subscribe, whether that's on YouTube or on Spotify or whatever platform you guys are using. Please make sure you subscribe. Please write us a review, comment on the videos and the podcast, and we'll see you guys next time. Hope you guys all have a